Hey, good day to you. This is Stan at Pachowski Estate Law, and this is Ask Stan today, Thursday, the May 21st, on time at 12 o'clock noon. And if I want to go over a couple things first, and that is what's coming up on the calendar and on the agenda. This Saturday, at the 23rd, at 10 o'clock in the morning, I'm going to have my free educational webinar about basic estate planning, will versus trust, and that. And we've given it a unique name. We're going to call this webinar, How Do You Want Your Estate Planned? Over easy or scrambled? And that pretty much tells the story. So tune into that. It's going to be 10 a.m. this Saturday at 10 a.m. So get a cup of coffee and join in. If you're interested, call me and call my office at 931-363-7222. Get the link from Alex or Tammy. And you can join my seminar this Saturday morning. This is the first time we did it on a Saturday and the first time we did it in the morning. So we'll see. What I want to talk about today is I'm going to talk about probate a little bit. I was on the radio this morning and that was the subject matter. It all stems from a question somebody gave me. Somebody asked the question, what is probate? Of course, that's a pretty broad question, encompasses a pretty broad answer, but we do a lot of probate here, and I'll try to cover it. I'm going to try and keep the Ask Stan show to about 10 minutes, but first I want to tell you what we're going to cover, and that is the subject of what is probate. Well, probate is actually a legal process, and it can be somewhat cumbersome, but let me see if I can explain it in general terms so you know if you get involved in that. Now, some of you may have been involved in probate or had a family member or a friend that went through probate, and so you may have been touched by it to some extent. Pretty much what it is if somebody passes away, and let's assume for the sake of argument that the decedent does have a will, okay? So they would have had a will, and they would put some language in that will about who gets their stuff, right? Who gets their property, who gets the house, who gets the farm, who gets their stuff. So what the probate court does is you go over to probate, you file a petition, you publish that will, the original will, along with a death certificate, and you have somebody called an executor. See, a will has to be executed, and that's where the word executor comes from. So when you have a will, the will gets executed, it gets executed, and the person doing that is the executor. Sometimes if it's a female, you'll see the term executrix. And if you don't have a will, you still have to open probate, but the person that will be placed in that position will be the administrator because you don't have a will to execute, but there is an estate to administer. Thus the term administrator, and sometimes the female administrator is referred to as administratrix. Not very confusing, just language. Okay, so the executor gets letters testamentary, which are letters that it really is the court's order, the court's official putting that person in control of the decedent's estate. Now, the decedent's estate really is everything that they own. And when you have an executor, think of that person, if you want to get straight in your head, think of the executor as a person who can stand in the shoes of the deceased and conduct their final business for them, pay their final bills, and then distribute their property. Just as if they were there in the room doing it and giving it out. That's what the executor does. It's called a fiduciary duty because, when you're executor, it doesn't mean, hey, you can go buy yourself a new car. It's not like that. You have a fiduciary duty to the well-being and the best interest of the estate and to do what the deceased asked to be done in the will. Now, I won't get into will contests and stuff, but if you do have a will, once you open probate, probate is where the will can be contested. And a will can be contested for just about any reason somebody wants to contest it. And some of those folks get pretty creative on what they want to contest. But that's where that would happen. If that was the case, the court would have hearings. I mean, you could contest what you take in a will. Let's say you got left a low percentage or nothing at all. You can contest that. You could contest who's the executor of the will. If you think you're a better person for that job, then you throw your hat in the ring and say, I think the person named for the executor is not the best person. I think I am. Of course, it requires going to court, and you're going to have to put forth proof as to why you should take more or why you would be the better executor or whoever. And then the court will decide. Okay, so if you can contest just about any aspect of a will, And if you don't like what you're taking, you can actually contest the validity of the will as a whole. If you don't think it was signed properly, witnessed properly, or formally executed properly, or if you feel that the decedent was not of sound mind when they did it. That happens a lot. It's a tough row to hoe when it comes to prove that the person was not of sound mind when they signed it, because it's really limited to the little area of time where they actually signed it. Because, some people have some dementia, but dementia is not 24/7. They have periods of time where they are lucid and can sign a will. So if somebody challenges it on dementia, and I've had that happen, we pretty much sit back and not worry about that too much, because it's very difficult for them to prove. Got to have medical records that show, and those are very hard. Medical people will not commit to the fact that somebody is not of sound mind 24/7. So, and if somebody like that came to my office and wanted to execute a will and they were not of sound mind, I wouldn't allow the will signing to take place, because, as an officer of the court, it's my duty to make sure the person signing, knows what they're doing. But any will contest will take place during the probate procedure. Now, once the probate estate is opened, now we've got to deal with creditors. Anybody that feels like the deceased owed them money can file a claim. Once probate's open, that's the procedural way to do so. So they'll file a written claim with the court. They'll have to do it in this 120-day period. And once they do, then the state will have to deal with it, meaning we'll look at it, we'll decide whether it's a meritorious claim, or if we think it's frivolous, we'll decide to pay it, or we'll decide not to pay it. If we decide not to pay it, the creditor is entitled to be heard at a hearing, and so there could be hearings. They show up and explain why they think the deceased should pay them, and we defend the estate as to why we think we should not. So that's the creditor period. Once we clear the creditor period, now we can actually start actual distribution of the assets, because now we're going to do the creditor or the executor's report and the inventory. So once we inventory everything, we will start to distribute. Now, early on, within 60 days after filing the petition, we would have sent everybody named in the will and all the known heirs at law a copy of the will and the petition, so that they know what they're going to get. So if you're named in a will and it says, hey, you get 25% of everything I own, now you sort of know what's coming. So if it doesn't come, or you feel or the executor becomes somewhat rogue, or is not conducting their fiduciary duty, or breach of their fiduciary duty, you now have a cause of action to try to enforce them to do what they're supposed to do, which is to give you what's coming to you in the will. So then we reach the end of it. We actually do the distributions. The personal property we divide, the money we divide, which is easy. If you have land or deed, sometimes not as easy to divide, but we will execute a deed at that point and the deed will now not be from Stan Perchowski, the deceased. It would be from, my son as executor of my estate to the deceased, to either the third party buyer, or to himself if I left the land to him, or to my 3 children with 1/3 undivided interest if I left all 3 to them. Just however it ends up being left is how that would be. So that's the inventory and distribution. Then we finally reach where we can close the estate out. Everybody's had their say, everybody's had their hearing. That usually runs in the neighborhood of 12 months up to 16 months, just depends. One of the fastest ones I've ever done was about 9 months, 9.5. And, the creditors, take some time, and just depends. So that's the probate process. I know the question says, what is probate? It's kind of a big question. It's kind of a big answer, but that's it in a nutshell. It can be kind of smooth and simple. It certainly is annoying, though. Probate is a procedure. And when you have something that's proceduralized like probate, it's almost like a cookbook in a way. You got to do step 1, step 2. You got to do certain timelines that got to be honored. Certain people have to be in the loop. We have to issue letters occasionally to let people know where things are going. If there's a hang-up, one time I had one where we had a hang-up where a creditor was taking forever to file their release, and we couldn't close the estate with an open claim. So, we sent a letter out to everybody and said, hey, look, we're all done, but the hospital's got some problem filing the release of the claim. And so we're, trying to get that cleaned up. So we keep everybody in the loop. That's usually the best way. Don't want to do anything that looks like we're trying to slide it under the table. One thing that comes to mind on a lot of cases is when we have a deceased that wrote a will, we get the executor in charge of that estate. One of the things the executor has to do is find out what all the deceased owned. And when I say that, it may sound relatively simple, but think about it. If you know the deceased and you're, best friends and family member, and you may know what all they own, but sometimes, you don't know what all they own. I mean, sometimes some of these folks in the older generation, they have assets they don't tell anybody about, they hide it. And you don't know where it is. So it becomes like a big scavenger hunt or something for you to try to figure out what all they own. Maybe they have an insurance policy, but if you didn't know they had one, what do? Just start calling all the insurance companies and say, hey, did Aunt Gertrude have an insurance policy with you? I mean, it becomes kind of cumbersome to do that, because if you can't find one, let's just say there's an insurance policy. I've got a case like that going on right now. Say there's an insurance policy and you just never find out that the thing exists. So you never include it in the estate and never gets distributed because nobody knows about it. But there is one. Well, what happened, I have the exact case. Somebody came to me. It's been like 12 years after the death. And what has happened was they received notice from the Tennessee Department of Unclaimed Property that there was about $13,000 in the Department of Unclaimed Property that was supposed to go to the deceased. And so we started looking into that, and here that we found out that's exactly what it was. It was a insurance policy, and the insurance company doesn't want this thing hanging out there forever. So they had in their policy, they had a condition that after 10 years after a death, if it's not been claimed, we're forking it over to the Department of Unclaimed Property. There's a lot of property in the Department of Unclaimed Property that gets that way. So that's why we have what is called the personal resources map, or inventory and accounting, to show everything you have. That way your heirs, or whoever you have, an executor, or if you have a trust, you got a successor trustee, they don't have to figure out what you owned. You will have categorized it all and organized it all, and then they can go to those individuals, and then they can start to divide those up. That's a plan. So if you haven't done that, think about it, because you ought to. And then it becomes more of a burden to your heirs to be the executor, because now, like I said, it's like a scavenger hunt. How do we know what they had? I actually had somebody, they couldn't find an original will. They knew there was one, but they couldn't find it. So they looked in desk drawers, they looked in safe deposit boxes. And it was kind of strange, because I got an email one day from one of the attorneys here in town. It was like his clerk. And the email was kind of generally written to all the members of the bar in a couple of counties, and kind of said, hey, I represent, Aunt Gertrude, and we know there was a will, but we can't find the original. Is there anybody, it's kind of all the bar. Does anybody in the bar remember writing a will for Aunt Gertrude so that we can get our hands on the original and stuff like that? So again, you just, just reaching out there, shooting from the hip. You don't know who did it. You know there is one, but you can't find it. You can't publish a copy of a will. If you can't find the original, then there is no will. So, which affects how everybody takes. So it can get ugly, usually does. And I haven't even touched on the issue of when people start fighting over what they get. And you just imagine how that goes. That usually clouds issues and makes things cumbersome as well. So, okay, so I'm usually trying to keep these ask stands more than 10 minutes, and I like to cover up front what I'm going to talk about. So that was the answer to the question, what is probate? Let me take a look and see if anybody has any questions. I don't see any. As usual, feel free to write a question to me, ask it live on my Facebook, call me and ask it. I'll answer it for you right then and there. I won't wait for the Ask Stan show. But if it's a good question, and they all are, sometimes I'll address it in general on the Ask Stan show. One last reminder, this Saturday at 10 a.m., I'm doing my regular seminar or webinar on estate planning. What we're calling this, because we got a Saturday morning theme, we're calling it, hey, how do you want your estate plan? Over easy or scrambled? And now we're going to talk about the will versus trust. So you can probably guess what a over easy estate plan looks like versus one that's scrambled. So I think that's pretty clever. My staff came up with that, so they're to be congratulated. Come on, sign into that. Call us, get the link, be there, listen to it. And I think it'll be educational. It'll be pretty eye-opening if you hadn't heard it. What else you got to do on a Saturday morning, right? The grass can wait. All right, thank you. That's the Ask Stan show for Thursday, May the 21st. see you next Thursday, or next Thursday on the radio show, or see you Saturday at my free educational webinar. All right, that's it for me. Thank you.